Hello, and welcome to another edition of Ask the Professor, a crowd-sponsored, crowd-driven feature where we respond to your questions about history, political philosophy, constitutional theory, foreign policy, culture, anything that matters to us in our common life as citizens. And today's question comes from Jeff, and he says, in the wake of the Harvey Weinstein scandal and the Me Too movement, he's been involved in a lot of discussions of how the law does or should define rape, sexual assault, and consent. And he asks, how did the common law define rape? What was its view of consent? And how does its understanding differ from the modern one? I think that is a very pertinent question. And the short answer is that the common law definition of rape was the carnal knowledge of a woman forcibly and without her consent. And the common law understanding of consent basically was that in order not to have consented, she had to put up continuous resistance. And you can see immediately a number of differences with our own understanding. In the first place, under modern statute law, rape doesn't have to be of a woman. It can also be of a man. Now, that doesn't mean that the law was indifferent to forcible sexual penetration of a man. It was covered under the old laws against buggery, which, of course, were connected with the fact that for a long time, homosexuality, whether with consent or not, was illegal. So, of course, we no longer believe that or have that in statute law, and we now do define sexual assault as either a man or a woman. Moreover, the carnal knowledge under the common law, of course this is going to be graphic because we're discussing sexual violence, was a penetration of the vagina. And so modern law also treats it as rape if there's penetration of anus or of the mouth. Again, it doesn't mean that the common law was indifferent to this. Again, it was put under a different heading, but it was still treated quite seriously. And obviously, we no longer require continuous physical resistance as evidence that there was not consent. If a woman goes into shock, or if she resigns herself to the fact that she's going to get raped, and that physical resistance simply means a savage beating as well, it doesn't mean that she agreed to the act. But you shouldn't think that because the old common law rules seem to be more restrictive in that regard, that people were more or less indifferent to rape. This idea that there was kind of a patriarchal system. Rape carried the death penalty. It was hard to prove, but if you did prove it, very serious consequences ensued. And under English law, by the way, it was certainly considered possible for a prostitute to be raped if she did not consent to intercourse. On the other hand, it was not considered possible for a wife to be raped. And our view on that matter also is very different. There's one more thing, by the way. I was puzzled to read some time ago that well, obviously you wouldn't have, statutory rape couldn't exist under common law because it's not based on statute. That common law did not deal with the issue of sex with minors. But in addition to the fact that, of course, it did deal with all sorts of other things like assault, it didn't really need to deal with that because as early as the Statute of Westminster in 1275, English law said that you could not have sex with a woman before she reached the age of marriage. Now, of course, the age of marriage in those days was considered to be lower than it is today, probably somewhere around the age of 12. And therefore, it would be legal with consent, though not without, to have intercourse with a 13 or 14-year-old. We don't allow that anymore, although Canada, like many jurisdictions, does make exceptions if the two people are very close in age. So, in some sense, our understanding hasn't changed all that much. Everybody pretty much knows what rape is. It's always been against the law. It's always been treated very seriously. But we do have a broader definition. We include men as well as women. We include different kinds of penetration. And we have a less restrictive definition of consent. So there has been a change in the law. And I think that there has been a change that is for the better. But it's not an enormous change. And as I say, just because something wasn't considered rape under the common law doesn't mean that it wasn't illegal. It might simply have been illegal under a different heading. So we need to continue to refine our understanding. But I think on the whole, it is more important that we continue to refine our understanding of the question of what is proof that consent did not exist. What might constitute sexual assault without rising quite to the level of rape. It's not a matter of the formal definition of rape, but of a better understanding of the context and a better sympathy for the victims Though, as I should add, it's also important to have sympathy for those who are falsely accused, and I see no reason why we couldn't have both. But on the whole, I think everybody's always pretty much known what rape was, and they've always taken a very dim view of it socially and under the law. If you're enjoying Ask the Professor and you'd like to submit a question of your own, this URL will take you to the appropriate spot. And if you think the feature is worthwhile, you want to support it and my other work, please click here and that will take you to a place where you can make a contribution, because we depend on you both for questions and for funding. Thanks for watching, and we'll see you next time.